Immigration Law Practice section. My name is Nirupa Netram, and we're so excited to have all of you with us today. Indira and I co-chair this practice section, and we wanted to talk a little bit about why we were champions of launching it. You know, we do have a large immigrant population in Southwest Florida and of course in Florida in general. And we really wanted this to be an opportunity to educate attorneys, community-based organizations on how immigration impacts the different practice areas. And we wanted to provide an opportunity to network and collaborate. So here we are today. I myself am a longtime attorney, 22 years this month. And I'm also a mediator, arbitrator, and I recently founded a consulting business around diversity and inclusion in the workplace. I do consulting, training, and keynote speeches. And I'm going to turn it over to Indira, and then we have a quick icebreaker for you. Indira?
Sure. Hi, guys. I'm Indira Demine. I am an immigration attorney here in Fort Myers. Like Nirupa said, we had this idea to have an immigration practice section for a number of reasons. But one of the things that I kept seeing is I would get calls from my colleagues in different practice area. So the criminal law section, family law, because immigration is so ever changing, there are new updates constantly. It's very difficult if you don't practice immigration law to know what is happening with immigration. And there's a lot of nationwide coverage about immigration, yet the details about how someone can go about and legalize their status, there isn't a lot of information on that part. So we wanted to create a place where we can collaborate. One of the things that I saw in the bigger cities, in the Miami area, in the Tampa area, there's a lot more immigration attorneys in that area. And there's a lot more opportunities to collaborate, network with your colleagues, and bounce ideas off of each other. You know, call your colleagues up and say, hey, I have this fact pattern. You know, how would you move forward with something like this? And I really miss that. Being in this area in Fort Myers, I feel like we're kind of secluded or on our own a little bit. But with the growing number of immigrants in our area, I think it's so important that we develop that sort of network of immigration attorney and that sort of support system, so that if a colleague does have a question about immigration, you know, they can reach out to people in the immigration practice section. So that's why we sort of created this. There will be, our goal is to provide opportunities, sponsorship opportunities, networking, and learning opportunities. The learning part is probably the biggest piece. And like I said earlier, immigration is constantly changing, and Adonia will go through some of the changes just within this last year. And even with COVID happening, there were a lot of major changes during this, the pandemic. So learning opportunities, what we're hoping to do is to share the latest updates, whether that be fee increases, whether that be changes in certain type of filings. We're hoping to create a list of interested individuals, so a database of folks that want to be on the database. And as we get updates, we can share that information out with you. And as you're meeting with your clients or family members of your clients, you can share that with them. So that's the idea of our little practice section here. Thank you all for joining us. We are hoping to have another meeting before the end of the year, and we're like I said, we're going to look for networking and sponsorship opportunities moving forward.
Thanks, Indira. And by the way, we are recording this meeting, so those that aren't here with us today can benefit. And just wanted to go around the room real quickly before we get started. And this has been a challenging year, to say the least. So we wanted to go around the room, and if you could share one win that you've had in 2020. So who's ready to go first? Please unmute yourselves, and we want to hear about that win that you've had this year. And it could be anything, small, big.
I'll go. Spencer Cordell. I don't do immigration. I do criminal and personal injury, but I had an injunction hearing this week that I won, which was just winning something and felt good.
Great. Who's next?
I can go ahead.
Sure, I'm about 95% no information. Every domestic case I've had since Corona hit. So a whole bunch of people have gotten sweet deal, everything from battery to sexual battery. So no information means they didn't even file on it. So mazel tov.
All right, so right now, for anybody that's joined us, we're asking about one win that you've had in 2020.
How you doing? I'm Taj Murphy. I work for a nonprofit organization, and we do immigration law and employment discrimination law. I'm the staff attorney on the employment law side, and I recently had a $30,000 settlement with a organization that discriminated against an individual on the basis of his national origin when he wasn't hired for a position because he did not speak Spanish in Miami-Dade County, despite the fact that he had seniority over another employee who was hired. So it was a good settlement, especially in this economy, for my client and also for the organization.
That's a great win. Congrats. All right, who's next?
Taj, I don't mean to interrupt. Where do you work out of? Miami or local?
No, I'm in Central Florida. I'm our Orlando attorney. We have attorneys in Miami-Dade County, but they focus on other aspects of the law. I do the employment law cases, so I cover the entire state, depending on where the need arises. But I'm in Central Florida, but the case was in Miami.
Can you shoot me an email? I mean, I get so many calls on my websites. That sounds like, you know, I don't handle it. If you don't mind, if that's okay, can we maybe get your email? I mean, this seems to be some area you specialize.
Sure.
I'm Michael Raheb at Yahoo. If you don't mind sending me your information so I have it, I appreciate it.
Let me write down your email again. What's your email?
Sure, it's my first and last name. I don't mean to interrupt, but it's Michael and then R-A-H-E-B, Michael Raheb at Yahoo. And I think we all get calls like that. If that's what you guys do, that's news to me. Great job.
Yes, please feel to chat the, and I see Lauren has chatted Michael's email here. I love the live networking happening right now. So anybody else want to tell us about their win? And you don't have to, everything's, voluntary.
You can go.
All right.
Hi all, my name's Adonia Simpson. We'll be chatting later on. This isn't particularly a win that's happened, that's been completely done, but I did want to report, I was talking to Narupa and Indira earlier, that we're currently doing a naturalization drive virtually, all via Zoom. We've been doing it for the last 2 days and we'll be continuing through Saturday. And our goal is to naturalize 400 individuals and help them on the path to become US citizens. And I just wanted to share it because I'm really excited about the way that we've used technology, and I'm so proud of all the people that have been able to engage. We have clients on their cell phones, on their laptops, on tablets, on desktop computers, and it's probably been one of the smoothest clinics and volunteer experiences I've ever been involved with. So that's my win, and hopefully a win for 400 future citizens.
That's a big win. Thank you so much for sharing, Adonia. Yes, applause, please. All right. Well, I don't see.
Yeah, I was naturalized. Good work. I wasn't born here. Nice job.
I was too. I was naturalized here, also an immigrant myself. So if there aren't any other volunteers, we're going to go ahead and truck on with our agenda. Our speaker today is the amazing Adonia Simpson, the director of the Family Defense Program at Americans for Immigrant Justice, a nonprofit law firm based in Miami. But Adonia travels to our area quite a bit, and she's been on national headlines. I call her the Queen of Immigration. And today she's going to share some Southwest Florida immigration updates and how they impact the different areas. So I'm going to turn it over to Adonia and Indira.
Thank you, Nirupa. You're making me blush. All right.
Okay, so Adonia will go through some of the latest updates, and at the end, I get some commonly asked questions, so Adonia will address those at the end. If you have questions, feel free to use the chat box to post your questions there. We will monitor that chat box, and this is anything immigration related, and I know some of you have reached out to me with your immigration questions, so feel free to use that chat box, but I'll turn it over to you, Adonia.
Sure. So as you can imagine, if we were to go over all of the immigration updates that we've seen, even in the last 6 months since the closures and everything with COVID, we'd probably be here a few hours. So I want to keep it to some of the highlights of things that have really happened recently. Immigration law is complicated. It can be, there's a lot of far-reaching consequences. Things that may not seem like a big deal can really impact individuals' lives. So I'm so excited to see this group come together and for there to be networking and for you all to be serving as resources to one another. Collaboration across practice areas is so critically important. I know as an immigration attorney, I frequently reach out to family law attorneys for clarification on issues that could impact my clients. So I really do encourage you all to use each other, and feel free to reach out to me. It sounds like Indira is willing to be a resource as well. So please collaborate on these issues. So there's so many things happening. So I wanted to kind of address the 3 ones that really impact a lot of the clients that I see right now. So one of the big things that's happened is Daca, which is the Deferred Action for Childhood Arrivals program. And I want to get kind of a show of hands if people are able to do the reactions. If people could just raise their hand on the reactions, if you have some immigration experience. Excellent, excellent. Good, good, good. Okay. So it looks like, we're split. So Daca, the Deferred Action for Childhood Arrivals program, was an executive order that took place under the Obama administration. For decades, individuals had been trying to get some sort of permanent legal protection for young people that came when they were children, that studied here, that have lives here. And unfortunately, Congress wasn't really able to pass anything to provide protection. So what we saw was an executive order that created this deferred action program. And deferred action has existed for an extremely long time. And what Obama essentially did was he applied it to a broad group of people, saying individuals, a big group of individuals that meet these requirements will be able to get deferred action, which means that the action being deferred is deportation, and the benefit is work authorization. So we've seen so many hundreds of thousands of young people benefit from this program. And we have seen a lot of litigation recently about the future of this program. Ultimately, the Supreme Court found that the termination of Daca by the new administration wasn't lawful. They said that the administration, yes, can terminate Daca, but they have to go through certain steps and take into certain considerations. So we saw that decision from the Supreme Court, and then what happened? It went back down to the lower courts to resolve some other issues, but then we saw USCIS, which is U.S. Citizenship and Immigration Service. They're the affirmative benefits processing arm of the Department of Homeland Security. They came out with a memo that didn't terminate the program, but went through a lot of things that really limited the program. So the first thing that this new memo, this policy memo did, was it limited work authorization from 2 years to 1 year. So this means that individuals, you pay $595 to apply for Daca and to apply for work authorization. And once approved, individuals would get a 2-year work authorization card that allowed them to, to work lawfully, get a driver's license, do a lot of good things. And now that work authorization is only going to be for 1 year, which means that in a year, people will now have to pay another $595 in order to renew that work authorization. The second thing that this memo did was it clarified that advanced parole, which is a type of application if somebody needs to leave the country for some sort of reason and want to ensure that they're able to return, barring some exceptions. Individuals with deferred action for childhood arrivals could only get advanced parole if there was some sort of exceptional circumstance. And the circumstances they listed were pretty dire, meaning a family member was very gravely ill. Previously, before the litigation, before there was action to terminate the program, individuals were able to apply for this advanced parole to be able to study abroad or to visit family. It was a great benefit to many young people. The third thing that it did was it reinforced that initial applicants, so first-time applicants, young people that never had Daca, would not be able to apply for the first time, which is huge because every day we have thousands of young people that become eligible for Daca, and unfortunately, they're not able to apply. They're not able to get work authorization. They're not able to try to get on some sort of stable status. So that's Daca. Do folks have any questions? If you have any questions, feel free. We're a small enough group. I will not be offended if you want to take yourself off mute and ask a question. I'd like this to be interactive. But DACA's been a big thing that impacts, particularly, I think Florida is number 4 in the country when it comes to DACA eligible and DACA recipient clients. So it really impacts a lot of young people throughout the state. Next, I wanted to chat about the changes that we've seen with temporary protected status, or TPS. TPS is a status laid out in statute and regulations, and essentially it gives the Department of Homeland Security the authority to designate certain countries that are suffering from civil strife or a natural disaster. It allows them to get some sort of temporary protection. And the protection, again, similar to DACA, is protection from removal and an employment authorization. And what happens is a country is designated for TPS, and then periodically it's reviewed by the Department of Homeland Security, and a determination is made whether or not to extend. What we've seen happen in the last couple of years, and particularly big developments in the last couple of weeks, is that we've seen that there's been moves to terminate temporary protected status for 6 of the 9 countries that have it. And what's difficult about this is there's some countries that have had temporary protected status since Hurricane Mitch. So since the late 90s, individuals have had this temporary protected status and have been renewing periodically. And so they have families, they have houses, they have roots and lives here in the United States. And a decision was made that country conditions in these countries, and the countries that I think particularly impact us in this area are Haiti, El Salvador, Honduras. Those are the big ones in our area where people are impacted. So we now have, hundreds of thousands of individuals that face losing their status. Similar to DACA, there was a lot of litigation, a lot of lawsuits. And what we saw happen last week was the Ninth Circuit Court of Appeals decided the Ramos case, where, and frankly, I don't consider myself an expert in litigation and appellate law, but given what happened with DACA, which had very similar arguments, I anticipated a very similar trajectory for temporary protected status. But what we saw on the decision from the Ramos case on the injunction was the Ninth Circuit said that the termination of TPS was okay. They lifted the injunction. So what that means is there's several countries that are going to be impacted by that. I believe it's El Salvador and Nicaragua. Technically, Haiti is exempt because there's other litigation pending out in the Second Circuit. There's still a nationwide injunction on the termination of temporary protected status for individuals from Haiti. But the other countries will have their status likely end in the coming year. The agreements that were made around the injunction is the Department of Homeland Security did agree initially to continue and automatically extend the status and the work authorization for these individuals through January 4th, 2021. And then depending on the country, there are certain rules about when they can make a subsequent determination to terminate the program. So if I recall correctly, and don't hold me to this, I should have made notes on this, I apologize. El Salvador, the program cannot be terminated more than 365 days from the decision lifting the injunction, and for the other countries, it's 120 days. So between Daca and TPS, we have about 1 million individuals nationwide that could be falling out of status and will face the really difficult decision on whether they want to return to their home countries or if they choose to stay here and remain undocumented. So a big push of immigration service providers, whether it's private or nonprofit, is to try and identify alternative avenues for these individuals. There's no direct pathway to permanency or a green card for people that have TPS and DACA. You know, by virtue of having TPS and DACA, you just can't apply for a green card. You have to have some sort of alternative basis to seek the benefit. So we see a lot of individuals who maybe marry U.S. citizens, or particularly for our folks that have temporary protected status, we're now seeing them have U.S. citizen children that are turning 21. So suddenly people are potentially having family members who may be able to petition. Is there a question? All right. And the reason I wanted to talk about TPS is, besides this decision out of the Ninth Circuit, we've seen some really disturbing memos come out from USCIS. There's been some pretty significant policy changes, which is contrary to more than 20 years of practice when it comes to individuals with temporary protected status who are seeking to adjust their status and become green card holders here in the United States. So one of the significant policy changes was a jurisdictional issue. So if somebody is applying for a green card, the primary agency that adjudicates that is USCIS. They're the affirmative benefits processing arm of immigration. And you would file your petition and your adjustment of status with them. Individuals who have been or are in removal proceedings before the Immigration Court, which is a separate agency that's within the Executive Office of Immigration Review, which is part of the Department of Justice. Individuals who have been or are in or have been ordered removed through this immigration court system, jurisdiction for adjustment of status generally vests with the immigration court. There are a few exceptions. One of those exceptions is if somebody is labeled something that's a legal term of art. It's called an arriving alien. It's someone that presents at a port of entry and is seeking admission into the United States, whether it's at an airport or potentially at a land border. So the exception to the jurisdictional issue for processing of these green cards is arriving aliens. So practice for decades was that I'll explain it through a fact pattern because that might be a little bit easier. We have an individual who has temporary protected status. They've had it for many, many years. They end up traveling on advanced parole, which we talked about a little bit earlier, which is the permission that you get from immigration to leave the country and return. And let's say this individual marries a US citizen. That advanced parole document was construed as giving them a lawful admission, which helped them in two ways. One, it helped for purposes of adjustment of status and seeking a green card, because generally that's something that is required. People that entered without permission, with some exceptions, aren't able to get a green card. So it served two purposes. One, giving you the lawful admission, and two, suddenly making you an arriving alien, which was great because we have a lot of individuals who had temporary protected status and maybe they arrived 10, 20 years ago, applied for asylum, went through the immigration court process, and unfortunately were denied. But during that process, perhaps received temporary protected status, which prevented their removal. So technically, one would think that USCIS would not have jurisdiction to process those green card applications, but the advanced parole document was what gave them the label of arriving alien and vested jurisdiction with USCIS. So the first change that we saw is that exists no more. USCIS is now saying that travel and advanced parole does not make you an arriving alien, so that they cannot adjudicate those cases. So I've seen dozens and dozens of clients who've paid well over thousands of dollars to immigration to file their adjustment of status applications, only to have the application be denied based on no jurisdiction. which then these individuals are being pushed into a circumstance where they're going to have to go to the immigration court and try to reopen their cases and seek to do the green card process before the judge, which, given delays and everything happening, it can be a challenge, and it's definitely something that individuals can't do pro se. They need an attorney. The second change that we saw, which was rather shocking, and I'm pretty surprised more people in the immigration community haven't been up in arms about this, but we just saw a memo come out, I believe it was the week before last, and Dear, correct me if I'm wrong. I'm blurs. I give up trying to figure out when things. But we saw this memo, another policy memo come out where now USCIS is now saying that travel on advanced parole, that document which allows you to re-enter the United States and that gave so many people that lawful admission they needed to be able to apply for a green card, they are now saying that you re-enter on the same status that you did when you first entered. So if you entered without permission your very first time and you travel on advanced parole, and even though that you've been paroled back into the country, immigration, again, contrary to a very long-standing policy and some case law, in my opinion, they're now saying that is not a parole, that is not an admission. So people that traveled on advanced parole after the date of this memo will not be able to use that for purposes of adjustment of status. So I'm bringing these two things up because we see the restriction of lawful immigration. We were seeing less and less options for people to take the steps necessary in order to become green card holders and eventual citizens of the United States. So that was a lot of crazy information on that. And I don't know if folks have questions. I hope that was pretty clear. I'm happy to answer questions if anything wasn't very clear about the procedural issues on that. But I anticipate that you all may see both Daca recipients and temporary protected status recipients that are suddenly confronting this issue of becoming undocumented again, with consequences.
I just want to jump in a little bit. Can you guys hear me? Yeah. So on a practical side, what has happened is that maybe last year, if I had a client come see me and I filed their adjustment of status, that client may have been granted, and this year they're being denied. And what we're seeing is a lot of confusion in the immigrant community. Well, my dad, we have the same status, we have the same exact case. He was able to adjust status, and having to explain this to my clients is very, very difficult because it's a difficult topic to explain to even lawyers. So imagine explaining this to a client that, yes, that was last year. What had happened was there was a change in law where even though you are an arriving alien, you're arriving to the US, technically you're no longer considered an arriving alien. Therefore, you're not eligible to file this, form of relief. It is extremely confusing, and there is a very large population here in our area, here in Southwest Florida, that is being affected by this. And I say that as a practitioner in this area. Last year, all of these cases that I filed were approved. And then what happened was that some USCIS offices were approving them while others were denying them. So if I had two cases, the same case, one that ended up getting an interview in Tampa and one that got an interview here in Fort Myers, I was seeing approvals come out of Tampa and denials coming out of Fort Myers for the same sort of fact pattern. So there was so much confusion surrounding this. What this change in policy does is that it forces that individual to file with the court, an already backlogged court system. A court system, majority of the cases here in Fort Myers are being filed with Miami. Miami court has been closed now for 5 months, so it was already backlogged, and now we're seeing an even more, a longer backlog, and all of these cases have to file motions to reopen with the court. So like Adonia said, this is just extreme limiting legal immigration. These are folks that have filed a green card application is $1,225. A marriage petition is $535. $1,760 in just filing fees. A medical exam is about $300 to $500. In addition, hiring private attorney to represent them on this case. You're looking at folks that have invested thousands of dollars into a case, and when they hired, I was telling them, yes, there's a pathway, and now trying to explain to them these changes, it's extremely difficult. So I just wanted to explain that.
And I think also these policy changes, besides forcing people back to the court, it's actually forcing a lot of individuals, given this most recent policy that came out 2 weeks ago, forcing more people to do something called consular processing. If USCIS is not going to recognize this as a lawful admission, it's trying to force more people to leave the country. And if you've acquired more than a year of being here unlawfully, you're subject to a 10-year bar. And in order to overcome that bar, you have to have a waiver. And to get that waiver, you have to show a hardship to a qualifying relative. So exactly like Indira said, there's people being pushed to court to deal with this, which is will delay the process an incredible amount of time, but also push people to try to do this process outside of the country, which really concerns me, because anytime one of my clients is thinking about leaving the country, I get nervous. There's very little access to counsel. As an attorney, there's very little that you can do if something goes south in the interview. Indira, I don't know what your feelings are on that, but
Absolutely. A client leaves the United States to complete an interview overseas. There's no guarantees at that point. And they cannot, even if they wanted me to go with them, I couldn't go with them to the interview. They, be by themselves, being interviewed by themselves. So absolutely, I'm with you with that. There's one point I wanted to bring up, just being a devil's advocate here, like, why are we being more restrictive when it comes to legal immigration? Do these folks have criminal history? Like, what is the thought process behind this? Everyone that is applying for permanent residency or legal status in the United States is thoroughly vetted. They go through a background check. So these are folks that have proven their good moral character, and are going through the legal pathways that are in place to allow them to legalize their status. So the argument that we are somehow protecting America or keeping dangerous individuals out by making these laws more restrictive, that just doesn't make sense. In reality, what we're seeing is folks that have been in the country for years, 10, 20 years, that have mortgages, that have small businesses, that have US citizen children, that are taxpayers, that have jobs, that are employers and employees, that are contributing to our local and national economy. Those folks are not being able to legalize their status. So I feel like there's going to be a trickle down effect on our economy once all of this plays out in the long run.
Absolutely, absolutely. And we've seen so many studies recently about how immigrants are essential workers, the contributions to immigrants when it comes to taxes and their spending power and their investment in our economies is incredible. If you're interested in this sort of nerdy stuff, which I am, the New American Economy has a lot of data, and they have it broken down just generally in regards to immigrants, but also specifically in regards to type of immigrants, so temporary protected status recipients, Daca recipients, and it actually breaks down those dollar amounts, not just for the state of Florida, but on a county specific level. So if you are, if you're ever in maybe a discussion with somebody on immigration, there's some really great facts and figures and numbers that really kind of support the contribution that immigrants make. And the last thing I wanted to bring up before we open it up to some questions, I think Indira had some questions that we wanted to chat about. Just to make this situation about getting a green card even more difficult, I wanted to bring up something called the public charge rule. This was something else that went through a lot of litigation, and then eventually it was ruled to be lawful. And the public charge rule is something that's existed a very, very long time. It's not a new concept. Essentially what it means is you could be found inadmissible and your green card could be denied if the government determines that you could become a burden on the government in the future and potentially take benefits or be some sort of burden. So this public charge determination has existed for many, many, many years. And the way that as immigration practitioners we usually dealt with it was there's a form called an I-864, which is the affidavit of support, which is completed by the sponsor. And if the sponsor makes a certain amount of money, great, there's never an issue. If the sponsor's money maybe didn't make enough money, we would get a joint sponsor, boom, never an issue. But what we saw happen was the introduction of new rules regarding public charge. And the consequence of it, what's interesting is in reality, what has gotten the most attention, in my opinion, isn't the biggest issue. So one of the changes was it stated if the immigrant received certain public benefits, whether it's Medicaid or like cash or food stamp assistance, for a certain amount of time, they would automatically be deemed a public charge. But guess what? Most immigrants aren't eligible for those benefits, particularly if you're not documented. Immigrants that tend to be eligible for those benefits are immigrants that if they're applying to get a green card are not subject to the public charge determination. So people that are here on humanitarian bases or have been survivors of domestic violence, those sort of individuals aren't subject to this test. So it really impacts people that are looking to adjust based on family or employment-based petitions. But those individuals, like I said, generally aren't eligible for benefits. So what happened? So the biggest issue was there was a leaked version of the rule that did not go into effect. And that leaked version said that benefits received by US citizen family members would be considered and go to this determination that somebody would not be eligible for a green card because they're deemed to be a public charge. So any guesses on what happened with that? The consequences of leaked information like that and this new public charge rule? Oh, I know somebody knows. Okay, I'll tell you. We saw thousands and thousands of people unenroll their children, their US citizen children, from safety net benefits that really ensure that we have healthy and happy children, right? Even though the receipt of those benefits shouldn't impact them. So there's been a lot of misinformation around this rule, and it's had a real chilling effect in communities, particularly now during COVID. We've seen a lot of individuals not want to get treatment or receive services or testing because they're afraid that it's going to lead to them being deported or not being able to get a green card. So it's become a complicating factor that is suddenly really outside of the realm of immigration. We're dealing with issues within families that is really causing a lot of problems. We see people not wanting to get unemployment benefits when they're eligible because they're worried that it's a public charge, which it's not. One of the benefits considered. But the bigger issue with public charge that doesn't get as much of attention, most of the attention is around this benefits issue, which, as I said, most immigrants aren't eligible. Those who are generally aren't subject to a public charge determination. The bigger issue is they've really started, factors have always been weighed, and they look at the situation in the totality of the circumstance. But now they've heavily weighted certain factors over other factors. And there's this new form, and I'm going to look at Indira's face as I talk about this form because I feel like I'm going to see, like, I don't know what sort of reaction I'm going to get for her. There's a new form that you now have to complete when you submit an adjustment of status application, which is called the I-944, which is the self-sufficiency, document of self-sufficiency. It's invasive. It asks a lot of details about education. It wants your credit history. You need to explain any negative credit history. If you have a credit history, if you don't have a credit history, you have to prove the negative. You have to prove that you haven't been receiving benefits. You have to provide evidence of your education, answer questions about your language abilities. So suddenly they're looking at a lot more factors more closely. So things like your age, your employment, your income, your health. So now certain things that may appear on your I-693, which is the medical exam that Indira mentioned earlier, that has to be completed. If there's something on there that shows that you might have a condition that needs continued care and you don't have insurance, well, that's a big negative factor. So essentially what this public charge rule has done is it's created a barrier, particularly for lower income immigrants to potentially get their green card. We're still very early in this process. The rule went into effect on February 25th, if I'm correct. So applications have been backlogged, and we might not actually see adjudications of these applications until sometime next year. But we anticipate that a lot of people could have their applications be denied because they're deemed to be a public charge, which then plays into other policies about notices to appear, which means if they don't have a status, immigration can issue them a notice to appear, which is the charging document, which puts them in immigration proceedings. And then the secondary, so the public charge rule has been a lot of additional work. And as I mentioned, it really does impact lower income applicants. USCIS has stated that there's an option at the discretion of the immigration officer to offer a bond. The amount of that bond is $8,100 minimum. So if somebody's already of low income and they've already spent all these thousands of dollars to submit this application, there's a potential of having to post an $8,100 bond in addition. So anyways, there's a lot of things happening, and that was a lot of information. So I want to,
there's Eunice asked a question earlier. I just wanted to make sure we addressed her. Her earlier question is, can you please address who has to fill out the I-944 versus the I-864? I think you mentioned that. And then the second question, can you explain the effect of the lawsuit regarding the I-944 form? I thought that certain states do not have to file the form. It's really confusing. Eunice, it really is confusing.
It is confusing.
I'll let Adonia address that.
So the I-864, some individuals are exempt from completing the I-864. So if you're an immigrant and you've worked 40 quarters, you can be exempt from having to complete the I-864, the sponsor. You don't need that from a sponsor. That's just one of the factors in the public charge determination. Immigration is looking at that I-864. They're taking a closer look than they used to. So they're looking to see what the relationship is. They want to ensure whoever the sponsor is actually good for it if something should arise and you become a public charge in the future. But it's part of the public charge determination, and it goes hand in hand with the I-944. In regards to the I-944, we've seen continuing litigation, and there's been injunctions for a week there. It was a nationwide injunction, and we were all very excited, and we tried to get these applications in, and then it was reduced to the Second Circuit. And then we saw the injunction was lifted. So it's been a lot of back and forth. Practitioners generally are of consensus that we have to do the 944, but what's interesting is it's hard to find on their website now. It's not where it should be, which is sending very mixed signals about whether it's needed or not. Our office, we are submitting that because there's another policy, which is called the NOID RFE policy, which immigration is within their rights to accept an application, take your money, and then if they deem that there was some sort of essential thing that was missing, they can say, oh, we're just going to deny. We're not going to give you an opportunity to respond. We're not going to do anything like that. So I'm being cautious now because it's so much money. I would rather err on the side of submitting an application that wouldn't be denied for failing to include an essential information. So Eunice, I hope that answered your question.
Yeah, so on the website, USCIS.gov website, you won't find the form, which is crazy. But technically, if you're in Florida, I believe the only state that does not have to file it is New York, right?
And I even think that was lifted.
Oh, okay.
Yeah, it's so hard to keep track of. Like right now, I'm just kind of in tunnel vision of like my clients, Florida.
I know we have to file it. So I know so our office is still filing it. Well, on the practical side, what does this form do or does? So it asks for a ton of information, a lot of which doesn't really apply to an immigrant. Have you ever filed for bankruptcy? What is your credit score? Have you ever had any governmental assistance? If you're an undocumented immigrant, most likely, most of those questions do not apply to you. So a good portion of it is no, and just, moving on to the next part of the form. The form is about 18 pages long. It is It asks for a lot of information, a lot of supporting documentation. For example, if you do not have a credit report, you have to show them why you do not have a credit report. So how does someone do that? If I cannot access a credit report, how do I show you that I cannot access a credit report? I don't have a social, you know? So it has definitely forced me to become creative in my, in the way we respond to immigration. But like Adonia said, there's also this very big push of like, okay, if you miss something, bye, you've just lost all your money. So as a practitioner, you know, where people are investing thousands of dollars in this filing, there's so much anxiety to make sure everything is done correctly, every box is checked, every documentation is submitted. Right now, if you're filing a marriage-based adjustment of status, you're looking about over 90 pages in just forms. Then you have supporting documents for your affidavit of support, supporting documents for your marriage, supporting documents for your declaration of self-sufficiency, biographic documents. So your filing, it could be hundreds of pages long. And in effect, what I have started seeing is, maybe because of the increase in the size of filing, USCIS is missing some of the documents in there. So I've gotten requests for additional evidence for birth certificates that have been filed, but they didn't see it, they missed it or whatever. So a filing now is so massive that even the adjudicating officer hasn't thoroughly reviewed the filing. So and it's just created, again, a lot of anxiety in the immigrant community for not just the immigrants, but for the attorneys that are filing these packets. So.
Awesome. Indira, did you have some other questions? Did we want to talk about some of the collateral issues?
Yes. So I thought about questions that maybe practitioners in our area may have, but of course, if you have questions that you want to ask Adonia, this is the time to do so. I have some questions written down that I think would be helpful. So first question, Adonia, if I have a client that has a pending criminal case, an ICE hold was placed on that client, how do I advise his family, and procedurally, what happens next?
Yeah, this is a huge issue that I have a lot of conversations. Actually, back in my prior life, I did criminal defense and immigration defense. So I was seeing my clients on the criminal side, and then when they came over on the immigration side, what generally happens is there's a detainer that's issued on the client, which is a request. First of all, it's a request, but when we look at it in combination with the SB 168, which is in the state law that says that best efforts need to be made to comply with ICE detainers, we really see everybody complying with ICE detainers. And the detainer is a request to hold the individual for 48 hours. That does not include evenings. I mean, it does not include weekends and holidays. So essentially, if your client is issued a detainer on a Friday afternoon on a holiday weekend, the client could be there a substantial amount of time. But when it comes to advising, and this is always a really difficult conversation to have with clients, well, first of all, you want to determine your client's status. If they're completely undocumented, regardless of what happens, they will likely end up in ICE custody, in detention. So you want to make sure to ensure that the client is set up in the best place possible. So when that happens, they have the best chance of bond. And what I mean by that is your initial inclination is to post a bond to get the client released on the criminal charges. Maybe it's a driving without a license, something that's not necessarily a big deal. But what happens in practicality on the immigration side is ICE will generally pick this, that they'll be held for those 48 plus hours. ICE will pick them up, ICE will process them, ICE will take them to immigration detention, which means that they're now sitting in immigration detention with an open case, an open criminal case, which can be problematic. Getting bond before immigration judges is incredibly difficult. You have to show that the person is not a danger to the community and not a flight risk, but there's a lot of judges that see any open case, even a driving without a license case, and automatically say danger to the community. So my recommendation for the criminal practitioners is to advise your clients to stick it out, to not post to get out of criminal custody, especially if you think that there's a really good chance that you can resolve the case in a positive way. Ideally, getting it dismissed is the best, because it's great for them, for an individual, so you can actually show that the charges were dismissed, and there's no conviction. Convictions can be very, very problematic, but so can open cases. And once your client gets into ICE custody, trying to get a habeas to get your client back into criminal custody to resolve the case can be pretty much impossible. I've never done it here in Florida. I used to practice criminal and immigration defense in Massachusetts, and we were maybe only successful in doing that 10-20% of the time. So that's something that you really need to speak to your clients and their family about. I've just seen a lot of clients go ahead and post the bail to get out of criminal detention, and they just slide right over into immigration detention, and it's a really hard fight, particularly if there's an open case.
Absolutely. And there's actually a case law that says even if you don't have a conviction, an arrest can be used, well, essentially against you in immigration proceedings in a bond hearing. So let's say, you know, you have a client that has been arrested for domestic violence and gets transferred over to Chrome with an open DV case. It's very, very difficult to get a bond at that point, because even if you think essentially this case is going to be resolved and it's going to be dropped, but it's taking a little while to get there, I would say keep the client in criminal custody until it's resolved. Because once you get to immigration custody, one, if you have court in criminal custody, getting that person back to criminal custody is a nightmare. I've never been able to do that. I don't actually think it's possible. But two,
in theory, it's possible. In practicality, it never happens.
Yeah. And two, it's the that arrest that can be used against them in immigration in their bond hearing, even though there's no conviction. So absolutely try to get it resolved. Another thing that I encounter quite a bit is, even if you get a criminal client and they're in criminal custody and they're like, look, I've never encountered immigration. So you're thinking that this is their first time in immigration custody. I would always ask, how did you enter the U.S.? And when you entered the U.S., were you stopped at the border by immigration CBP officers? That question is so important, because a lot of times you'll hear, oh yeah, I was, but it was only for a couple of hours and then I left, and and then I came back the next day. Well, if you were stopped at the border, and depending on what happened, there's catch and release, you're caught and sent back. But a lot of times you're caught, you're fingerprinted, you're given an expedited order of removal at the border, and then you're sent back. If that person now, 20 years later, got caught driving without a license, now they're in ICE custody, that old order of deportation from 20 years ago can be reinstated, which becomes an issue just moving forward and trying to get them out of custody. So that happens quite a bit. So I think that's an important question to ask your clients.
Yeah, and for folks that don't practice immigration law, the immigration court system is a very strange place. It's civil. So sure, you can have an attorney, but you're not going to get a court-appointed one. So the numbers, particularly in detention, particularly right now during COVID, the number of individuals that are unrepresented is huge. So if the person ends up in ICE custody, in immigration detention, the likelihood of being able to get an attorney is very low, and there's a very good chance, the stakes are high. If an individual isn't, the burden is on the respondent to prove eligibility for relief, which means that we see the majority of people being ordered removed, which can have huge consequences.
Okay, we're going to switch gears to family law. Let's say I have a client, she tells me she wants to get a divorce, but she has a pending petition that was filed by her U.S. citizen spouse. How should I advise her?
This is tough. Family-based petitions sometimes are the bane of my existence. They get so messy. From an immigration practitioner side of things, a lot of times we're doing dual representation. So a lot of times we represent the petitioner or the U.S. citizen on the petition and the beneficiary or the immigrant on the adjustment of status application. And I can't tell you how many times things start breaking down in a relationship And on the immigration side, a lot of times we are conflicted. It can create a conflict, and we're just conflicted out of the whole case. Particularly if there's allegations of maybe abuse or mistreatment, things like that. We're out on the whole case. But if you're a family law practitioner and somebody approaches you and they have a pending petition, a pending application for a green card based on a petition by their U.S. citizen spouse, there are huge consequences. To get divorced, particularly now given the backlog, it could take a couple of years to actually get their green card adjudicated. And before the time of adjudication, if the marriage does fall apart and they seek divorce, the individual is no longer eligible. And given policies we mentioned before, there's a chance that an individual could be issued a notice to appear and be put in removal proceedings before the immigration court. So there's a lot of different issues. One, the consequences on any pending applications. If they're already a green card holder and they have something called a conditional resident card based on being married to their spouse for a very short amount of time, we see this happen a lot. The consequences of divorce are much less. There are waivers. If you establish that it's a good faith marriage, you can remove the conditions on that green card. Another thing that as a family law practitioner that you want to be aware of is if there are any allegations of domestic violence or mistreatment. Immigration under the Violence Against Women Act has created this, and even despite the name, it's not just for women. They've carved out this concept that there can be a balance in equity between a U.S. citizen petitioner and an immigrant spouse. And so if there is some sort of abuse or domestic violence or even just threats or coercion, there's a potential that that immigrant can do something called self-petition. So even if there's an application pending that would be which would be denied if the marriage fell apart, if there's an argument that the individual was abused, you could potentially do a self-petition and do the process that way.
Okay, we have a couple minutes left. I did want to ask, how do you find out if a client is in ICE custody? And how do I find out if a client is in deportation proceedings?
Sure. Those are always big things to do. I'm sharing my screen with you guys. First, to find out if they're in ICE custody and where they're at, there's this nifty website called locator.ice.gov. It's from ICE. And you can search for clients this way. My recommendation is always try to get an A number. The A number is their 9 or perhaps 8 if they've been here a really long time, digit immigration identification number. So with their A number and country of birth, you can locate where your client is potentially detained at. And the immigration system, just because a person's from Florida doesn't mean they'll be detained here in Florida. It's all based on bed space and capacity and what's happening on their case. If they have a prior order of removal, they may end up in Louisiana and be on the next flight out of the United States. So when you look on here, don't be surprised if your client maybe isn't still in the state. They could be moved elsewhere. You can also search by name, first name, last name, country of birth, and date of birth. I don't recommend this because there are always so many spelling errors, whether it's on the ICE side, maybe they put a hyphen or they don't put a hyphen, or they put a space, or they only include one of the last names. This can be a really challenging way to find your client. So if at all possible, ask for an A number. It would appear on any immigration paperwork they have, on a green card, on a work authorization. It appears in a lot of places. So that's how you can find where your client's detained at. When it comes to finding if your client has court or has been in court, EOIR, the Executive Office of Immigration Review, thankfully finally is getting with the times and does have an online version. Prior to this, we actually had to call an 800 number that was an automated number, and you had to enter in all these numbers to get to the point where you entered in the A number. But now you can look it up online with your client's A number. And by putting an A number in here, you can see if there's no information that shows, that means that that A number is not in the system, which could mean the notice to appear hasn't been filed with the immigration court, or they've never been before the immigration court. If they are in the system, it will show if there's any upcoming court dates, where they are, when they are, with what judge. If they had been in court previously, it will show the ultimate disposition as far as whether or not it was appealed to the Board of Immigration Appeals, or whether, you know, there was a final order of removal. So this is a really handy system. I always tell my clients, even though I may be checking, they should check. They should be empowered to have the 800 number or the website and know their A number and know how to check to ensure that, especially now with COVID, so many cases are getting postponed. It's a lot of confusion. We're finding out a week or two in advance about closures upcoming or postponements. So things are constantly changing, and we're having to prepare for cases that we think are going to be going forward in a month, but they're probably likely going to be postponed, but we want to be prepared. So anyways, that was a ton of information. I'm sorry I talked really fast. I know we're running out of time, so.
Thank you, Adonia. I'm going to have Nirupa finish off today's meeting.
Right, just a reminder, this is being recorded and going up on the bar's wonderful YouTube channel. I'm now chatting the CLE code, which is 2001-50N. And I also chatted my email earlier. If you could send me suggested topics or future speakers. I want to thank our speaker today, Adonia Simpson, and of course our other immigration queen, Indira Demine. And thank you all for joining us today. We hope to see you again, and I hope this was helpful to you. Bye, everyone. Have a
Take care, everyone. Bye.
Thank you.
Bye.
Looks like Michael had a question. Michael, do you want to stay on and I can just, oh, it looks like he's gone. Oh, no, he's there. You moved.
That's a big thing to always get is how do you prove it? Because sometimes I've got cases all over Florida and I can't get the answer to this. How do you actually prove they're deported? You know what I mean? Like little receipts.
For purposes of the criminal case?
Yeah, because you get criminal too. You know, some prosecutors will say, Michael, I'll no pros if you tell me they're deported. Some will say, go jump in a lake. So
yeah, I actually had a long conversation with the Miami-Dade Public Defender's Office on this because they approached us with the same thing, the same issue. Like, we can get it no pros if we can show evidence that they've been deported. And the tricky thing is in theory, ICE should be able to give you that information. But if you're not the immigration attorney of record, if you don't have a G-28, they're not going out of their way to help you on that. Another option could be potentially.
So if I track the attorney of record, because I've asked them this, they would have it? They would have a proof that says your guy's deported?
They could request it. They wouldn't necessarily have it. When somebody's deported also, oftentimes they're supposed to go check in with the consulate and provide paperwork that shows that they are actually outside of the country. This information could come from a FOIA. You can do a Freedom of Information Act request to try to get it. My suggestion to the Miami-Dade Public Defender's Office actually was to ask the judge to issue an order, the criminal judge to issue an order to ICE to produce evidence of the deportation. I don't know if that would actually.
That's never going to happen here. This is Trump land. That's not happening.
Yeah.
Miami, I can see it. It's not happening Trump world. But okay, I'll remember that because most of my people, they had immigration lawyers, and some of them that just eat, sleep, breathe immigration. And I've asked them, and they've and hawed. But if you tell me it can be done, then I'll say
it can be done. It's not easy. Like, one way is through the FOIA. One way is having, ensuring the client checks in with the consulate abroad and getting evidence. You can get evidence from. They'll give you a document that proves that you're gone.
Getting a hold of the guy in Guatemala to do all that. All right, it's not easy. I'm not the only one. I was just.
It's not easy, and I've been approached with this question before by other defense attorneys. So.
Cool. Thank you.
No problem. Sorry, I know we went over. I just saw the question and I thought it was a good question.
It was a good question. Thanks, Michael.
Bye-bye. Thank you again.
Spencer, you look like you may have a question.
Spencer looks like he's going to Hawaii.
Yeah, all right. I'm just waving bye. Thanks.
Bye. Thanks for joining.
Bye. Thanks, everyone. Have a great weekend.